3 reasons why your judge is angry. Now, if we think about this logically from the court's perspective, and you think about the fact that on any given day, a judge may have 20 cases on their calendar, maybe as many as 30. And then you think about two parties in each case, that's anywhere from 40 to 60 angry people who are fighting over every little thing. And it becomes somewhat repetitive, right? There's a lot of similarities in the things that people argue about, although we are each individual. So there is a little bit of variance, but it becomes really repetitive. And then when the court is angry, that means that you're being remembered in a negative way, which is not good for your case. When we're talking about this issue, I know that if you have an attorney, you might not feel like this is as important. And one of the points I'm going to give you is kind of more applicable to self-represented people. But I always say that your own personal conduct and the way that you act inside and outside the courtroom, honestly, can have a far greater impact on your case than the attorney that you choose. And I'm not saying that some attorneys aren't more talented than others or more experienced or more, more knowledgeable or whatever the case may be. That's true. As in any profession, there are people who are better and people who not so much. But in family law, the judges are really trying to get down to the core of the issues and figure out what's really going on in this family and what things can we put in place to try to give them as much success as we can. So your conduct becomes very, very important in this situation. Now, if you are self-represented, I find one of the things that can be really upsetting for the court, depending on the judge, some are more patient than others, but a lot of times it's because we don't know procedure, right? We just show up. We might not have filed documents on time. We might not have even brought documents. We might not be prepared for the hearing. And honestly, if you are in a position where you have to self-represent, which happens, right? Having an attorney is very, very expensive and self-representation happens. But if you're taking on that responsibility because you can't afford it, then you have a responsibility to educate yourself and to understand the timelines. When we file documents, when we submit exhibits, when we do all these things, the court has timelines and procedures for all of these things of when they have to be filed, when they have to be served on the other side. All of those types of procedural things you really need to educate yourself on and understand, because when you don't do those things correctly, you make the judge's job harder than it already is. If something doesn't get timely filed, guess what? Especially in this world of electronic filing for everything, that document might not even make it to the judge before your hearing. And then the judge is like having to backtrack and maybe try to find the document and read it, or just proceed without it or whatever. And then they proceed without it. They don't have your side of the story. You feel frustrated because your stuff didn't get heard, but really the judge couldn't help that procedurally you didn't do what you needed to do or didn't file in time or whatever. So these things become really critical to you being able to advocate for yourself. Even if you have an attorney, I will tell you that it's helpful to know those timelines and procedures. Now, you don't have to know every timeline, but if you have a hearing coming up, you can say to your attorney, hey, what's our timeline? What's our deadline for, filing this or filing our response or submitting our evidence or whatever? If you ask those questions, they will tell you, because for an attorney, what usually happens is there's so many different cases going, and we've got deadlines every day in our offices, right? I mean, I'm not an attorney, but my late husband was, and I worked as his paralegal. So there was a new deadline every day for court, just about it. I mean, multiple a week for sure. So really, we're kind of almost always in fire, extinguishing mode, where we're just on to the next deadline, the next deadline, the next deadline. So really, by the time we get to your deadline, depending on how many cases we have going and how many different are going to court and all this kind of stuff, by the time we get to you, we might only have a few days to put it all together. But if you know in advance and you can kind of be prepared and have all your stuff done and to your attorney, to where when they do get down to that couple days and they're ready to deal with your issue, everything's right there in front of them that they already need. Okay. So we do try to work as far in advance as we can, but I'm just saying that there's always times where you have trial or you have something going on where the attorney is just like last minute getting to, your particular hearing for whatever reason. And it's not personal. It's nothing like that. It's just kind of nature of the beast. and wait the way things go. But again, you can do things to help counter this and to make sure that your stuff is completed timely according to the procedural guidelines. Now, the next thing that happens, and I think this is a big one that we see a lot of times, particularly out of, well, not just self-represented people, both, but particularly I think out of self-represented people, because if you have an attorney, they're going to tell you this and you may not listen, but it's because you're not following court orders. So when the court tells you to do something, you need to do it. Like if the court says start therapy, then start therapy. And the hard part with this particular piece is a lot of times we go into court and maybe we're doing a modification on custody or whatever. And one of the orders that comes out of it is, the parents will take a high conflict class or the parents will get into co-parenting therapy or whatever. And then the court's done and over, right? Those are your orders. That's your modification. Everything was addressed and you're done. So really there's nobody that comes along to make sure that you're complying with that court order. The court kind of leaves it to you. The problem is if something happens that you then come back in front of the court in 3 months or 6 months or 9 months or whatever it is with a problem, then the court's going to go, oh, you didn't comply with my order. And when they see that, it makes them feel like the person doesn't have respect for the court and like the person is, non-compliant because you're non-compliant with those orders. Okay. So it's real important that you follow through on things, even if it's at kind of the end of your case where nobody's going to sort of double check you or anything. It's still important that you do that for future success of your case. I tell clients this all the time, like the earlier I get a hold of somebody, the better it is, because people don't understand and don't make the connection of how what they're doing right now is going to affect your outcomes down the road, a year down the road, 2 years down the road. And when we're going through custody things, if you have a high conflict person on the other side, there is always a down the road, right? Just about it until they turn 18. So you want to make sure that every time you're in front of that judge, you're complying with all the orders, you're doing what you need to do. If there's an order that you use a parenting app, use the parenting app. Don't text, don't try to call, don't have a side agreement with the other person that you don't have to use it. Like if the court ordered you to use it, use it. That's complying with the order. I find that with custody in particular, those things you need to be flexible. I don't want you being rigid about that. If the court says the exchanges are going to take place at the Walgreens down the street and one of you moves and it's like, okay, can we now do the McDonald's over here on this corner? Sure, agree with that. You can agree with that, okay? Or if somebody needs to change a time or delay things an hour or whatever, to the extent that you can on custody issues, you need to cooperate and you need to agree. So I'm not talking about that kind of thing. I'm talking about when the court orders that you specifically do something. Like we had a client at one point that was ordered to get a drug and alcohol assessment and never did. And then like a year later went back into court because I think the other parent was withholding the children and said, hey, the other parent's withholding the children, and just kept getting met with resistance from the court and couldn't figure out why. And finally hired my late husband to go to court. And my late husband, I remember him standing in front of the judge and going, well, Your Honor, what's the court's concern? And the judge was like, well, this person was ordered to do drug and alcohol assessment last year, and I still don't have a drug and alcohol assessment. So I can't do anything else until that's done. But the client never made that connection, right? It took, Thomas going in and kind of figuring out, oh, okay, here's the deal. So it's important that you follow through and that you comply with those court orders. Otherwise, your judge is going to be mad. They told you to do something that you didn't do. Third, this is my favorite one. You talk too much. This happens so much in family court. And this doesn't just happen if you're self-represented. A lot of times this happens even when you have an attorney present. And if you're self-represented, it is worse and the risk is higher. But again, this kind of goes back to number one of understanding the procedures of how things flow. It's like if you go in for a 20-minute hearing, you can't stand and talk for 15 of that. Like you've got 3 to 5 minutes max. Because then the other side has to talk, and then the judge, and then one of you might need to chime in again or whatever. And the judge needs some, to allow some time in there for things. So you can't just take the floor and talk for 15 minutes straight. And if you try to, what happens is they cut you off. And I have so many people who will reach out to me feeling so frustrated that they didn't get to say what they felt like they needed to say. Now, a lot of times what you're standing up there saying are emotional things that don't impact the outcome of what the court's going to order anyway. And that's the other reason that the judge cuts you off, because they feel like you're talking about things that aren't relevant for the orders that they're going to make. So again, understanding all that, what's important, what's not, how long do you actually have procedurally? Okay. It's important that you not try to tell your whole entire life story. You have to hit your key points, a couple of examples if you need to, and not rehash information that the court already has heard, or not try to, I just want the judge to know. When somebody says to me, I just want the judge to know, I always say, stop, time out. That's a feeling statement because you want to be heard. I want the judge to know. If the judge isn't going to make an order, them knowing something isn't really helpful. A better question is like, okay, what can the judge do about this issue? If the answer is nothing and you just want them to hear it, take that to your therapist or to your coach, not to your judge. Your judge, you bring things that they can actually make an order and try to help fix the problem for you. And if the order you want is that the other parent not be a jerk, well, there's no magic wand that will achieve that. I wish there was. We would all be a whole lot richer, but no, there isn't anything along those lines as of yet, okay? And even if you have an attorney, I have seen this happen. Again, going back to my late husband, there was a case about 5 years ago where he went in and there was a little boy that was, 7 years old or so. And he went in on an emergency basis and said, Your Honor, these things are happening in the other home. We're concerned, blah, 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 blah. And the judge is kind of nodding her head. Yes, she's kind of like going along with Thomas and she's getting it. And then all of a sudden the client pipes up and says, Your Honor, can I say something? And Thomas is just like, he's sitting over there like, ooh, like, no, like, don't say anything. Because he's got it going in his direction and he knows he does, right? And this is what we trust our attorneys for. If you're going to have an attorney, trust that they have the ability to handle your case. If you don't trust them to do that, you need a different attorney, okay? But you have to have faith in the attorney that you choose. And what happened was this client said their piece, and then the court went, oh, well, what this client essentially said is like, this has been a problem for a while. And this is, for the last 2 years, it's been blah, blah, blah. And then the court went, oh, it's been happening for 2 years. Well, this isn't an emergency. So nope, we're going to set it for a regular hearing and you'll have to come back. And, Thomas was so frustrated because he had the court going in the direction that he wanted and he was about to get those emergency orders until the client piped up. So again, you have to understand this process and what's happening and why your attorney is doing certain things or why you need to do certain things so that you can avoid shooting yourself in the foot. Because when you do these things, you make your judge angry. They remember you for negative reasons. And then when you come back again, they remember it. And that's not good. Think of the volume of cases that judges have. They have 3,000 to 4,000 active cases generally at any given time. And then if they're remembering you out of all of those and they're angry in that way, then guess what? They're remembering you in a negative way and it's probably not a good sign. So we want to do what we can to reverse that. And this is where it starts. So I hope this information is helpful. If you would like more, learning and education and coaching on these types of things to help you understand how the court works, how they think, and how you really need to approach your case to be able to have success, you can go to divorceuniversityonline.com/VIP-coaching. There's information on that page on my group coaching programs for moms and for dads. And there's also information about my high-level VIP one-on-one premium coaching services. All right. Thanks for joining me. I'll see you guys next time.